The department also sent to Congress an 8 bill anti-fraud package in September, and it has announced plans to install a new computerized file on white-collar crime suspects that would link officials in 64,000 law enforcement agencies. Terrorism incidents of international terrorism multiplied in number and intensity during 1985. Attorney General May stressed his determination to deal with such incidents as criminal act for which the perpetrators must be brought to justice. Investigation into the hijacking of TWA Flight 847 in June led to the issuing of arrest warrants for terrorists involved. Similarly, warrants were issued for the arrest of those responsible for hijacking the cruise ship Achille and the murder of American Leo Klinghoffer. The Attorney General has met with his counterparts from a number of nations in Western Europe to discuss ways in which international cooperation against terrorism can be enhanced. Moreover, the Department of Justice has availed itself of the provision in new mutual assistance treaties and expanded criminal jurisdiction provided by long-arm statutes aimed at terrorist acts directed against Americans anywhere in the world to pers- people Republic of China and Israel. Notable among these were the cases of John Walker and his son Michael, both of whom pled guilty, and Larry Chin, who was convicted on all counts. Antitrust reform of the nation's century-old antitrust laws has become a top administration and departmental priority. The Attorney General and the department played a key role in formulating the comprehensive antitrust proposals agreed to by the cabinet late in 1985. The proposals, which were introduced in Congress in early 1986, represent the first major efforts to overhaul the basic antitrust status since their enactment around the turn of the century. The proposals reflect the administration's conviction that current law fails to take into account to broad international scope of competition in late 20th century world trade prevents certain pro-competitive businesses activities and mergers and unfairly deters and penalizes some activities which would otherwise actually enhance competition and economic health. The reforms include changes in treble damages, attorneys' fees, and amount of claims. Office of the Solicitor General. The Solicitor General, with the assistance of a small staff of attorneys, is responsible for conducting and supervising all aspects of government litigation in the Supreme Court of the United States. In addition, the Solicitor General reviews every case litigated by the federal government that a lower court has decided against the United States to determine whether to appeal and also decided whether the United States should file a brief as amicus curiae in any appellate court. A significant part of the work of the office involves government agencies that have conducted lower court litigation themselves, such as the National Labor Relations Board (NLRB) and the Securities and Exchange Commission. In addition, many cases arise from activities of executive departments of the government. During the past term of the Supreme Court, July 1984 to July 1985, the office handled 1,000 1,08,084 cases. 1,884 cases, 38% of the 5,006 cases on the court's docket. Table 1 of the 4,429 cases acted to during the term. There were 1,421 in which the government appeared as the respondent, 42 petitions for rights of certain field or supported by the government, and 17 cases in which it appeared as amicus supporting the respondent. 10 cases where the office either represented the appeals or appeared as amicus curiae supporting the appeal. In addition, the office participated in 4 cases on the court's original dockets. Of the 3,997 petitions of rights of cessioner dockets and acted upon, only 4% were granted during the term. Of those filled or supported by the United States, 80% were granted. This reflects the careful screening of the government cases by the Solicitor General and his staff before the decision is made to file or to support a petition. Of the 13 appeals filed or supported by the government, probable jurisdiction was noted by the court in 9 Table 2A and B. The government participated in arguments or filed briefs as amicus curiae in 114, 65% of 175 cases argued on the merits before the Supreme Court. Of the cases decided on the merits with or without arguments. The governments participated in 1,146 of 236 cases, 77% of which were decided in favor of the government position and 2% of which were decided particularly in favor of the government's position. During the same period, there were 637 cases in which the Solicitor General decided not to petition for certiorari and 1134 cases in which the Solicitor General was called upon to decide whether the authorized taking a case to one of the courts of appeal, plus 428 matter. This made a total of 4083 substantive matters the office handled during the year.